Wow, good crowd this morning. Welcome to anybody that's new. Welcome to the people that are returning. This is our now regular monthly webinar. For anybody that's new to me, I'm John Miller, the senior attorney, founder and owner of Rock Solid Law and Title, located here in Ponte Vedra Beach and founded here 32 years ago now, I guess. If you're not familiar with the firm, of course, we practice in estate planning, which is the subject of this morning's chat, real estate closings, residential and commercial. And we love representing entrepreneurial business owners. I feel like small business is the heartbeat of American business and our economy. Home ownership is the cornerstone of the American dream. And of course, estate planning is the way in which we act as family preservation attorneys to keep families strong, because I believe that the nuclear family is the most important unit in our culture here in Florida and in the United States of America. So this morning, I've got a lot of ground to cover. For those of you that are new, there is a chat bar, and let's see how I do, about right there. If there's something you want to ask, please type it in there, and I will be delighted to answer any questions. I usually hold those to the end. If it is something that I've misstated or something you didn't understand and it's right in the flow, I'll try to work it in at that point too. So don't be shy. I love interaction. If something is really personal and fact specific, I would say it'd be better if we took it offline, not with the whole group. So that is a possibility too. And stay tuned for the end of the webinar, where I will make you guys a little concession, a special offer just for joining me this morning. Love to work with families in the Northeast Florida region. Obviously been doing so for quite a long time. Have a great team here at Rock Solid Law to do so. So today we entitled this webinar Trust 101. I'm going to try to accomplish three things. It's a lot to do in approximately 25 minutes, but I think I can do it. First, what is a trust, and in what ways does the building block trust of a family estate plan benefit you and your family? Two, how are assets transferred into a trust? In other words, what is a trustee in charge of that's in the trust? And do you know what funding is? There's a little hint. The last two are related. I'm sure I'll think of other things that I want to work in this regard, but those are the main things I'm going to cover this morning. Pretty basic level today, right? So what is a trust? There are probably 100 or hundreds of kinds of trusts. They are for everything for dynastic multi-generational planning to tax planning, for current and future generations, all sorts of ways in which trusts are used. The trust we're going to be talking about today is a revocable or revocable, both pronunciations being correct, family living trust. I said it all those ways because you're going to hear them called all of those different things. You're going to hear them called a living trust. You're going to hear them called a family trust or family living trust, and you're going to hear them called a revocable living trust. All living trusts are revocable. There are irrevocable trusts, and those are a subject matter for another day. They typically have to do with asset protection and tax planning. So that's a little deeper than we're going to go today. So what are the benefits of a trust, of a family trust, of a living trust? First and foremost, it is that you absolutely maintain the same control that you have over your assets right now. The minute before you sign them or the minute before you fund them, you have complete control of them. And afterwards you do too, assuming you've named yourself trustee, which just about everybody does. The cool thing is that you can then appoint whoever you want in the world to be in charge of whatever is in the trust when either you are incapable of doing so, incompetent anymore, and science has greatly improved, medicine's greatly improved, we're outliving our brains in a lot of instances, and we're not able to take care of ourselves. Well, you have chosen who will take care of you. Just a quick flash forward. When we do a trust in this practice, we prepare all the other documents that you need to, which include a pour over will, power of attorney, healthcare, surrogate living will, etc. There are some etceteras, but that I don't want to talk about this today. So you remain completely in control of all of the assets which you place in the trust. And our recommendation is that you place all of your assets in the trust, because anything that is not placed in the trust and doesn't have proper death beneficiary language will go to a probate. I'm working with a family now where unfortunately death beneficiary wasn't properly done, and we're having to go through the court system. Probate means court. Probate means expense. Probate means time delay. Probate is where families go to fight. Probate means your heirs inherit immediately upon the conclusion of the probate. So that brings me to my second point about what is really cool about a trust is that you write the rules inside of that trust. So perhaps you have minor children and you don't want them to inherit $1 million or even several $100,000 at the age of 18. Right? Which they're legally entitled to do. Why? I've seen it too many times. I'm in my 7th decade, guys. So somebody inherits young in their teens or 20s, they blow it all. And then they spend a life of regret that they had what a great opportunity, but they no longer have any way to recover that opportunity. So only in a trust can you make the rules of how those funds or other things will be distributed after you're gone. Okay, after you're dead, you will have rules, and many families have benchmarks. Had one this week. A bachelor's degree is the first benchmark, and then ages. And when I started practicing in the 80s, a lot of people were inheriting, in their 20s. It's well into the 40s now, folks. A lot of people step it out into the 40s. I'm very fond of saying that no child is happy when they see that their parents are making them wait to get that money. But nobody who's in their 40s and gets that last tranche and that second shot in their lives are bitter about their parents having made them wait, because they now know what it really means. We just make decisions differently in our teens and 20s than we do in our 40s. Along those lines, in the event that they have inherited in their 20s, and the divorce rate in this country, it's over 50% now, and they have that bad first divorce, the future ex-spouse has inherited half of what you left behind. So by stepping it out into the more mature ages, you're guaranteeing that that's going to stay among your heirs, the people that you love, and how you choose to give it to them and when you choose to give it to them. Now, another benefit is that, of course, with a will, which means a probate, right? Every will goes through probate. That means a court suit, which means somebody appointed by a politician is making the decisions about what happens to what you leave behind. I've done this a long time. There are a couple of things nobody ever says. One, I want to give the IRS as much as I possibly can. Nobody ever says that. Two, I want the government to decide how my stuff is to be distributed, right? Nobody wants that. Okay. Now, in fairness, in a probate, you have suggested who will be the personal representative, and they will be in charge, but they're under the supervision of a judge. And you don't know what that judge is going to be like. And you don't know if they're going to be fair or unfair. And I have seen incredibly unfair in my recent practice. I'm happy to say not in Northeast Florida. It's elsewhere in the state. But that's a risk you don't want to take. So if you put it in a trust, you can decide when people are going to get money, including right away if they need it. There's a delay with probate until the judge says that money can be spent. What if one of your heirs needed a medical procedure immediately and had to wait and the money was there? That timing could make a difference in their life. Your trustee, in all likelihood, you will have given the discretion to pay for the procedure that's needed, right? So that's just another good reason. The other reason I was getting to a moment ago, court is semi-public, right? A lot of court records are accessible to the general public, to snoops, to your neighbors who want to see what you have, right? Well, a trust is completely your secret. You share it with who you want, when you want, and you don't have to tell anybody in the world what's in there, including your heirs, until the time comes that it is put into play after you are no longer able to manage it. Okay, so a trust, a revocable living or family trust, takes care of your heirs, allows you to choose the timing, and completely avoids probate. Those are the main benefits at the very basic level of what you can decide. Also, of course, you decide who's in control rather than having some court-appointed person be in control. So a lot of times people ask me, and I'm just going to touch on this, well, what do you consider? When should I get a trust? Okay, basic rule, every family is different. Every person is different. It's all fact-driven. It depends on the values of the person with whom we are doing estate planning. All right. So my rule of thumb, right, is if a person or couple has assets in the $300,000 range, we want to start thinking about a trust, looking at the other fact scenarios and what that person's values are and how they want their estate to be preserved. Then we get to $500,000. I'm usually tending toward a trust rather than a will in this scenario, just because the simple cost of the trust is only a couple thousand more than the will package. And the cost of the probate at that level is going to exceed $5,000. So you could have had a trust in the first place and not spent any more money long-term than your family ends up spending. Okay. You get up to $750,000 or $1 million, you're definitely in the range where a trust is appropriate, right? A lot of us in Florida have real property, right? Because real property in Florida is a great way to build wealth. One of the reasons that I practice in real property law, and that's counted as well. The fair market value of your real property, of course, is as much a part of your estate as your 401k and your market trading platform and your savings at the bank and that money that's in your pillow or a mattress or whatever you call it. Believe me, literally that happens in this world. And thank God for attorney-client privilege, so I don't have to talk about that. So that's when we start to think about a trust. And again, every trust package does have a pour-over will with it and all of the other, we call them ancillary documents, the power of attorney, the healthcare surrogate, all those things that you need to make sure that you're fully taken care of during your life so that you're not going to go in front of a judge in a guardianship should you become incompetent. All right. Deep breath, halfway point, although I'm a little past half on time. No, I'm doing good. I don't like the term funding of trust, but somebody long time ago decided we were going to call it funding a trust. Think of it this way. The trust is only in charge of whatever you put into it, right? So you could conceivably make a choice to leave something outside of a trust. For instance, let's just say a life insurance policy. You could have that directly paid to a beneficiary. Why do I recommend usually paying it into the trust? Because then those funds are subjected to the rules that you've written of the trust. If you leave life insurance directly to a person, they inherit immediately. Sometimes that's your spouse, and that's a good thing. Now, listen, we're not going very deep today, but on qualified retirement funds, there's a little bit of a different avenue because of the stretch rules and the way that they have been modified recently. So that's something we need to consider in each individual case, how you will do the death beneficiary on qualified funds and what the alternate would be. Okay, just a little, that's a footnote. So funding a trust, I think a better term would be retitling, because that's really what we're doing. Funding of trust is moving the title to the things you own into the trust so that they are therefore under the auspices of the trustee. In almost every case, the trustee during your life and during your capacity, as long as your brain's working well, is you, right? So that's why I say you're in charge of it. Now, funding a trust, think of this. You're getting ready to go on a trip. You get your suitcase out of the closet. If you just pick up that suitcase out of the closet and take it to the car to go to the airport and it's empty, it's pretty useless, isn't it? You got to put some stuff in it. You need your clothes. You need your whatever recreational things you're going to do on that trip, packed up and ready to go. Funding is the packing, right? So keep that suitcase in mind, and we're going to move things into it. The things we're going to move into it may be stocks and bonds. They may be real properties. They may be retirement accounts. They may be curios and special things that you own that have particular value, that Picasso that your grandmother handed down to you or whatever. It's all of the things that you need to have controlled in the trust so it smoothly goes to the next generation. All right. Smoothly goes is not what typically happens in probate. Okay. I can't tell you, I'll finish a speech, live one, and somebody comes up and tells me what Uncle Bob did at the funeral. Right. And I've got my war stories too, and I'm not going to bug you with those today. So packing that suitcase full of all the items. Now, listen, another reason you want to avoid probate is because probate is expensive. You know who profits in probate? The lawyer, the accountant, the appraiser that gets hired, because the PR has a fiduciary duty to maximize the estate, right? So all those professionals together, you're going to end up losing about a minimum of 10%, sometimes as much as 30% of the value of the estate before it ever gets to your kids. Now, sadly, I have to tell you that there are a lot of law firms whose business model is to take your money to create a trust and then give you a piece of paper that tells you how to fund it, knowing full well that by my estimate, 96% of people will never accomplish that task fully. Send you off in the world with a pile of papers that are not actually effective in any regard in the manner in which you created them, unless the case goes to probate. And guess where the heirs are going to go to probate that lawsuit? You got it. Right back to the same lawyer. So really, it's like building an annuity for that lawyer, building value in his or her law firm that they're going to sell. And I don't think that's right. And that's why with every single package of estate planning that this firm provides, we include funding. We include going through all of your assets and making sure they are appropriately retitled so that they will avoid probate. That doesn't mean everything's going to go into the trust. Some things we may choose to do a death beneficiary, POD, TOD on. Some things we may choose to title in another way. For instance, with real property, we have enhanced life estate, nicknamed Ladybird deeds, that we can use in that regard. We have quick claim deeds to put people on title. We have lots of alternatives under the law on how to take care of you and your family, right? But we're going to look at each one of those, and we're going to give you our very best advice on how to do it. And also, we have people on our team that do it regularly. So they've been through this. Can we go to the bank and sign your name? Even if you stayed in a Holiday Inn Express last night, you know the answer to that is no, we can't sign your name. But we can get in touch with the right people and get the right forms so that it's easy as all get out for you guys to go in and retitle these assets into your own name, into the name of the trust, so that the probate will be avoided and the trust will work properly. Okay. So in every case, we need your cooperation, but we will help you get this funding part done. Because listen, I began to practice in 1984. You can do the math. Until about 5 years ago, I didn't understand the importance of funding. And I gave the instruction to people of what to go do. With our firm, we follow up with people. We don't want to be a single transaction. We want to have a relationship with you. So when we were calling people back saying, did you get that done? The universal answer was, no, I've been meaning to. It's on my list of things to do. I'm going to get to it, which is sort of the same answer they gave us for 20 years of not quite getting around to doing their will or trust yet, right? With great intentions. Doing that work is not something that's high on people's priority list. All right. Can you beat me up and swear you're going to do it and get me to not include that in your package? Yes. And I'm going to follow up with you. And if you actually do it, you will be the first client ever to actually perfectly fund their own trust and move forward. Let me tell you how often I have clients come in and they've got a notebook. I can't show you, but there's some of them right there. This other lawyer prepared this for me. I have no idea what I've got. Did you fund it? No. What does that mean? Well, it means retitling your assets so they're controlled by the trust. So most important step, the first step, actually stopping procrastinating and getting it done. Next most important step, figuring out who your fiduciaries are and how you want to leave whatever's left over to whoever or whatever you love. You want to leave it to charity? Oh my gosh, I love doing that work. All right. Fantastic to participate in charitable endeavors. Next, coming in to sign. You won't believe how many people get all the way to that point and just can't seem to actually come in and put ink to paper. Listen, by that point, with my firm, you've made all the decisions. So it's just a sign-in party. And we push back from the table and we go, yes, it's done. And people say that it is a relief off their shoulders that's been there for decades. But we're not done then. We've got to fund it. We got to pack that empty suitcase so that that person has something more than a pile of papers on their plan. Now, listen, I know we're going to be doing a signing Friday afternoon. And the couple is then taking off to an island together. One of the moms is taking care of the kids. Well, obviously, from Friday afternoon to their flight on Saturday morning, we're not going to get the funding done. But they go with the assurance that in the very worst case scenario, they will have their documents in place. They will have chosen who will take care of their children. They will have chosen who will take care of their money. And we could file that pour over will, which would put all of their assets into the trust. I know pour overs are a subject outside of today, but from the moment of signing, you are taken care of. Gosh, guys, I know I've gone on. I can't believe how that time flew by. I hope it was as quick for you as me. I get excited about this stuff because let me tell you, people say, why do you do what you do? I started out as a trial lawyer. I was good at it, but it was stressful, man. Getting hired by other people to fight over their problems just wasn't my gig. So I figured out by being a commercial litigator that I loved working with business owners. And so I began doing their transactional work. And then when I came to the beach in 91, I realized my businesses were smaller than they were when I worked for a bigger firm downtown. And so it was 2 or 3 folks. Well, listen, I had to know their family side to be able to represent their business side well. So in the 90s, I began to gear up. And from then to now, have been offering estate planning, which includes trusts, right? Very importantly includes trusts, to my clients, and have built my expertise from then to now. I happen to rent from a real estate lawyer. So I incorporated that because with every business owner and every family, there's typically real property or real property to come. Plus, Florida is a great place to build your wealth by buying investment property. So from the 90s to now, I've built that practice. And about, 3 or 4 years ago, I was invited into a nationwide collaborative, really with some of the highest end estate planning lawyers in the country. So I used to say I was very good for Dolphin Cove here in Ponte Vedra, and I say now I can manage the Boulevard. I'm a really, really good estate planning lawyer, but I have access to a lawyer who's become a mentor of mine who literally who literally taught a generation of the highest end planners in the country. And it's just a delight to work with him in that regard. So I have him available for those that need him. We're able to plan with those who don't without his assistance. Wow, I'm running up against time. I'm not seeing any questions. I can't believe I was possibly that sincere, not sincere, I am sincere, succinct this morning. If somebody has one you want to type in real quick, I would take a question or two from you. I do always try to respect your time and get out as close to 9:30 as we can. While I'm waiting to see if anybody does have a general question, I want to thank you very much for joining today. And in response to your being here with us today, I want to offer you a consultation with our firm, with one of the lawyers in our firm, me or Walt, and we'll waive the charge. That's almost a $500 savings to your family. So we would love to talk to you and figure out what you might need. And if we can figure out what you need, then we will talk about what the fee is to prepare that for you. All right. So I do have a question. Thank you very much, Jerry. Absolutely. This and all the videos that we do in our webinar series are available at rocksolidlaw.com/videos. Can't remember exactly. I think you just have to put your email address in there. And there's a whole wall of videos. This one should be uploaded in the next day, and it will be there for you to watch with your family. And man, I got to tell you, it's a good start to the day when somebody wants to show their family what we've just been talking about. It is a passion of mine to help families with this process because I believe in American families. We are the future of our country. And I like keeping families tight. I'm going to cue the Commodores back up with Zoom. I am so grateful for your joining today. If you have a question that's too personal or fact specific to put on the chat board, send it to questions@rocksolidlaw.com. If you want to make an appointment, call 904-241-1113. That's 241-1113. Just let them know you're on this webinar and that I indicated that I would waive the consultation fee. Everybody, I hope you have an amazing day. And thank you so much for spending these 30 minutes with me. I'm John Miller, senior attorney, Rock Solid Law and Title, building a rock solid foundation for your family, business, home, and wealth.